Good, good evening. So, we're now in the Bill of Rights. Verba, Juris, Bar Review Notes, Volume 1, Political and International Law, under topic of Bill of Rights. Concept of Bill of Rights. The three fundamental powers of the state, the exercise of police power has been characterized as the most essential, insistent, and the least limitable of powers, extending as it does to all the great public needs. It may be exercised as long as the activity or the property sought to be regulated has some relevance to public welfare. Vast as the power is, however, it must be exercised within the limits set by the Constitution, which requires the concurrence of a lawful subject and a lawful method. Thus, our courts have laid down the test to determine the validity of a police measure as follows. First, the interests of the public generally as distinguished from those of a particular class requires that its exercise and through the means employed are reasonably necessary for the accomplishment of the purpose and not unduly oppressive of an individual's privacy and autonomy. In this case, the acts complained of were not related to or not of no direct relation to respondent's work. Respondent's work. Official duties and functions. Nevertheless, respondents' private acts may still be reviewed by the court because every court personnel are enjoined to conduct themselves toward maintaining the prestige and integrity of the judiciary, for the very image of the latter is necessarily mirrored in their conduct, both official and otherwise. They must not forget that they are an integral part of that organ of the government sacredly tasked in dispensing justice. Their conduct and behavior therefore should not only be circumscribed with a heavy burden of responsibility, but at all times be defined by propriety and decorum, and above all else beyond any suspicion. Relation to human rights. Relation to human rights. We believe in human rights and we protect and defend them. Petitioners are entitled to the full enjoyment of all the rights granted to them by law. And this court stands as the guarantor of those rights. Due process of law. In criminal cases where the life and liberty of the accused is at stake, due process requires that the accused be informed of the nature and cause of the accusation against him. Nature and cause of the accusation against him. Hence, any accused not clearly charged in the complaint or information for the offense could not be convicted of it, or for to convict him so would be to violate his constitutional right. Concept of right to life, liberty, and property. 1987 Constitution was crafted and ordained at a historic time when our nation was reeling from ghastly memories of atrocities, excesses, and outright violations of one people's rights to life, liberty, and property. Hence, our Bill of Rights was worded to emphasize the sanctity of human liberty and specifically to protect persons undergoing custodial investigations from ignorant, overzealous, and or incompetent peace officers. The Constitution so dearly values freedom and voluntariness that inter alia it unequivocally guarantees a person undergoing investigation for the commission of an offense not only the services of counsel but a lawyer who is not merely a competent but also be independent and see preferably of his own choice. Kinds of due process. Essentially, constitutional due process requires that the party affected by the correction be given an opportunity to present his side of the question, particularly where the petition itself manifests that the purpose of the correction of the entry sought is to lay a foundation for future litigation against the party so affected. Kind substantive. That a man's job is property right within the ambit of constitutional protection has been long recognized and accepted in law. Hence, we are circumspect and vigilant whenever a worker comes to this court complaining of illegal dismissal. In such case, we require the employer to prove by substantial evidence the facts constituting the ground for dismissal, and that termination has been effected with strict observance of both procedural and substantive due process. It is by these standards that the court has judged the instant petition. Kinds procedural. The demands of procedural due process that the party affected must be given notice and an opportunity to be heard must be fulfilled together with the law's policy for the prompt proclamation of the true winner in the elections. The summary character of the proceedings, if implemented with a firm hand so as to rule out impertinent and irrelevant questions and dilatory tactics, would normally not cause any undue delay in the ensuing proclamation, and if some measure of delay were entailed, nevertheless, the due process requirement may not be dispensed with. Lack of notice to a party adversely affected as invariably held to mean the nullity of the decisions rendered in ordinary civil cases, since they suffer from a fatal infirmity for want of due process. As stated by the now Chief Justice in Kwai Kong Sengbenko, acts of Congress as well as those of the executive can deny due process only under pain of nullity, and judicial proceedings suffering from the same flaw are subject to the same sanction. Any statutory provision to the contrary notwithstanding, the thought that lies behind this safeguard is the belief that thereby the accused is afforded further protection, that his trial is likely to be conducted with regularity and not tainted with any impropriety. It is not amiss to recall that Delegate Laurel, in his third summation of the importance of this right, singled out its being a deterrent to arbitrariness. It is thus understandable why such a right is deemed embraced in procedural due process, kinds, judicial. According to the same decision, it is only when there is a statute granting no such right, and still it is denied to the accused in spite of his demand, therefore that there is a violation of the due process clause of the Constitution. More authoritatively, in my opinion, in Hashim versus Munkan, no less than Justice Laurel took occasion to say, viewed in the light of fundamental principles, the right of preliminary investigation is statutory, not constitutional. They sought recourse from 3 different tribunals in order to obtain the writ of injunction they so desperately desired. The willful attempt by private respondents to obtain a preliminary injunction in another court after it failed to acquire the same from the original court constitutes grave abuse of the judicial process. Due process of law guarantees notice and opportunity to be heard to persons who would be affected by the order or act contemplated. Trial court is not justified because of its legitimate desire to expedite termination of a case which has been dragging on for years, in denying defendant the precious constitutional right to present witnesses and evidence in its defense. For such a denial amounts to deprivation of property without due process of law. Kinds, again, administrative. Due process in an administrative context does not require trial-type proceedings, similar to those in courts of justice, where the opportunity to be heard either through oral arguments or through pleadings or is accorded No denial of procedural due process takes place. Levels of scrutiny. The absence of due process is that a party is afforded a reasonable opportunity to be heard in support of his case. What the law abhors and prohibits is the absolute absence of the opportunity to be heard. The most basic tenet of due process is the right to be heard. Denial of due process means total lack of opportunity to be heard in order to have one's day in court. Equal protection of laws. Concept. This simply refers to the equality in the enjoyment of similar rights and privileges granted by law. Phrased differently, the Equal Protection Clause under the Constitution means that no person or class of person shall be deprived of the same protection of laws which is enjoyed by other persons or other classes in the same place and in like circumstances. In a landmark case, the Supreme Court had the occasion to define equal protection in this wise. To all persons and things similarly situated, the law shall be applied equally, that is, to be treated alike, both as to right conferred and responsibilities imposed. Requisites for valid classification. Equal protection clause under the Constitution means that no person or class of persons shall be deprived of the same protection of laws which is enjoyed by other persons or other classes in the same place and in like circumstances. The power of the state to make reasonable and natural classifications for the purposes of taxation has long been established, whether it relates to the subject of taxation, the kind of property, the rates to be levied, or the amounts to be raised, the methods of assessment, valuation, and collection. The state's power is entitled to presumption of validity as a rule. The judiciary will not interfere with such power absent a clear showing of reasonableness, discrimination, or arbitrariness. In subsequent cases, the Supreme Court had consistently reiterated its declaration the Equal Protection Clause is not absolute. It permits of reasonable classification. If the classification is characterized by real and substantial differences, one class may be treated differently from another. Levels of scrutiny. From its traditional modest role, equal protection burgeoned into a major intervention tool during the Warren era, especially in the 1960s. The Warren Court did not abandon the differential ingredients of the old equal protection. In most areas of economic and social legislation, the demands imposed by equal protection remained as minimal as ever, but the court launched an equal protection revolution by finding large new areas for strict rather than differential scrutiny. A sharply differentiated two-tier approach evolved by the late 1960s. In addition to the differential old equal protection, a new equal protection connoting strict scrutiny arose. The intensive review associated with the new equal protection imposed two ends: legislation qualifying for strict scrutiny required a far closer fit between classification and statutory purpose than the rough and ready flexibility traditionally tolerated by the old equal protection means had to be shown necessary to achieve statutory ends, not mere reasonable or related ones. Moreover, equal protection became a source of ends, scrutiny as well. Legislation in the areas of the new equal protection had to be justified by compelling state interests, not merely the wide spectrum of legitimate state ends. The Warren Court identified the areas appropriate for strict scrutiny by searching for two characteristics: the presence of a suspect classification or an impact on fundamental rights or interests. In the category of suspect classifications, the Warren Court's major contribution was to intensify the strict scrutiny in the traditionally interventionist area of racial classification, but other cases also suggested that there might be more other suspect categories as well: illegitimacy and wealth, for example, but it was the fundamental interests ingredient of the new equal protection that proved particularly dynamic, open-ended equal protection that proved particularly dynamic, open-ended, and amorphous. Other fundamental interests included voting, criminal appeals, and the right of interstate travel. According to the strict scrutiny standard, a legislative classification that impermissibly interferes with the exercise of fundamental right or operates to the peculiar class disadvantage of a suspect class is presumed unconstitutional. In sum, the doctrines of strict scrutiny, overbreadth, and vagueness are analytical tools developed for testing on their faces. Statutes in free speech cases, or as they are called in American law, First Amendment cases, they cannot be made to do service when what is involved is a criminal statute. With respect to such statute, the established rule is that one to whom application of a statute is constitutional will not be heard to attack the statute on the ground that impliedly it might also be taken as applying to other persons or other situations in which its application might be unconstitutional. As has been pointed out, vagueness challenges in the First Amendment context, like overbreadth, the challenges typically produce facial invalidation, while statutes found vague as a matter of due process typically are invalidated only as applied to a particular defendant. Right against unreasonable searches and seizures. It is well settled that no arrest, search, and seizure can be made without a valid warrant issued by a competent court. Without a valid warrant must be valid. Issued by a competent judicial authority. Competent judicial authority. One of the recognized exceptions to the need of a warrant for a search may be effected is a search incidental to a lawful arrest. Concept of privacy. Section 2, Article 3 of the 1987 Constitution provides that the right to be secure in one's papers and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. Right to privacy is defined as a right to be free from unwarranted exploitation of one's person or from intrusion into one's private activities in such a way as to cause humiliation to a person's ordinary sensibilities. Concept of a search. Under Section 13, Rule 126 of the Rules of Court, a person lawfully arrested may be searched for dangerous weapons or anything which may have been used to constitute proof the commission of an offense without a search warrant. Requisites of a valid warrant. To paraphrase this rule, a search warrant may be issued only if there is probable cause in connection with a specific offense. connection with a specific offense alleged in an application based on the personal knowledge of the applicant and his or her witnesses. This is the substantive requirement in the issuance of a search warrant. Procedurally, the determination of probable cause is a personal task of the judge before whom the application for search warrant is filed, as he has to examine under oath or affirmation the applicant and his or her witnesses in the form of searching questions and answers in writing and under oath. The warrant, if issued, must particularly describe the place to be searched and the things to be seized. We paraphrase these requirements to stress that they have substantive and procedural aspects. Apparently, the RTC recognizes dual nature of the requirements and hence treated them separately. It approved of the way the MTC handled the procedural aspects of the issuance of the search warrant, but found its action on the substantive aspect wanting. It therefore resolved to nullify the warrant without, however, expressly declaring that the MTC gravely abused its discretion when it issued the warrant applied for. RTC's error, however, is in the form rather than the substance of the decision, as the nullification of the issued warrant for the reason the RTC gave was equivalent to the declaration that grave abuse of discretion was committed. In fact, we so rule, as the discussions below will show. Jurisprudence teaches us that probable cause as a condition for the issuance of a search warrant is such reasons supported by facts and circumstances as will warrant a cautious man in the belief that his action and the means taken in prosecuting it are legally just and proper. Probable cause requires facts and circumstances that would lead a reasonable, prudent man to believe that an offense has been committed and the objects sought in connection with that offense are in the place to be searched. Implicit in this statement is the recognition that an underlying offense must, in the first place, exist. In other words, the facts alleged, taken together, must constitute an offense, and that these acts are imputable to an offender in relation with whom a search warrant is applied for. Warrantless arrest or warrantless searches. A search may be conducted by law enforcers only on the strength of a valid search warrant. Exceptions. The instances where a warrant is not necessary to effect a valid or seizure, the determination of what constitutes unreasonable or unreasonable search or seizure is purely a judicial question. Judicial question, taking into account, among other things, the uniqueness of the circumstances involved, including the purpose of the search or seizure, the presence or absence of probable cause, the manner in which the search and seizure was made, the place or things searched, and the character of the articles procured. Whereas warrantless search preceded a warrantless arrest that was substantially contemporaneous with it, what must be resolved is whether or not the police had probable cause for the arrest when the search was made. Persons may lose the protection of the search and seizure clause by exposure of their persons or property to the public in a manner reflecting a lack of subjective expectation of privacy, which expectation society is prepared to recognize as reasonable. Such recognition is implicit in airport security procedures, with increased concern over airplane hijacking and terrorism has come increased security at the nation's airports. Passengers attempting to board an aircraft routinely pass through metal detectors. Their carry-on baggage as well as checked luggage are routinely subjected to X-ray scans should these procedures suggest the presence of suspicious objects. Physical seizures and conducted to determine what the objects are. There is a little question that such searches are reasonable given their minimal intrusiveness, the gravity of the safety interests involved, and the reduced privacy expectations associated with airline travel. Indeed, travelers are often notified through airport public interest systems, signs and notices in their airline tickets that they are subject to search, and if any prohibited materials or substances are found, such would be subject to seizure. These announcements place passengers on notice that ordinary constitutional protections against warrantless do not apply to routine airport procedures involving seizure of a dangerous drug from a passenger during a routine frisk at the airport. The Supreme Court ruled that such evidence obtained in a warrantless search was acquired legitimately pursuant to airport security procedures instances. Consented searches as an incident to lawful arrest, searches of vessels and aircrafts for violation of immigration customs and drug laws, searches of moving vehicles, searches of automobiles at borders or constructive borders where the prohibited articles are in plain view, searches of buildings and premises to enforce fire, sanitary and building regulations, and stop and frisk operations. In the instances where a warrant is not necessary to effect a valid search or seizure, the determination what constitutes a reasonable or unreasonable. Warrantless arrests and detention. A valid warrantless arrest which justifies a subsequent search is one that is carried out under the parameters of Section 5A, Rule 113 of the Rules of Court, which requires that the apprehending officer must have explored by probable cause to arrest a person called in flagrante delicto. In flagrante delicto. The rules of court recognize permissible warrantless arrests, to wit arrests in flagrante delicto, arrests effected in hot pursuit, arrest of escaped prisoners. In flagrante delicto, hot pursuit, escaped prisoners. Exclusionary rule, however. Let's have a break. Ice cream. We're having a break. Ice cream break. positions. Lika. So let's start again. We're now on the exclusionary rule. Page 98 of the book Verba Juris by David Robert Aquino. Exclusionary rule. However, most common law jurisdictions have already given up this approach and eventually adopted the exclusionary rule, realizing that this is the only practical means of enforcing the constitutional injunction against unreasonable searches and seizures. The language of Judge Learned Hand, as we understand it, the reason for the exclusion of evidence competent as such which has been unlawfully acquired is that exclusion is the only practical way of enforcing the constitutional privilege. In earlier times, the action of trespass against the offending official may have been protection enough, but that is true no longer. Only in case the prosecution, which itself controls the seizing officials, knows that it cannot profit by their wrong, will that wrong be repressed. Effects of unreasonable searches and seizures. In the case at bench, we find that the checkpoint was set up 20 meters from the entrance to the Batasan complex to enforce resolution number 2327. There was no evidence to show that the policemen were impelled to do so because of a confidential report, leading them to reasonably believe that certain motorists matching the description furnished by their informant were engaged in gun running, transporting firearms, or in organizing special strike forces, nor, as adverted to earlier, was there any indication of the package or behavior of Arellano that could have triggered the suspicion of the policeman, absent such justifying circumstances specifically pointing to the culpability of petitioner and Arellano. The search would not be valid. The action then of the policeman unreasonably intruded into petitioner's privacy and the security of his property in violation of Section 2, Article 3 of the Constitution. Consequently, a firearm obtained in violation of petitioner's right against warrantless search cannot be admitted for any purpose in any proceeding. Effects of illegal detention. Under Article 2217 of the Civil Code, Moral damages include physical suffering, mental anguish, fright, serious anxiety, wounded feelings, moral shock, and similar injury, while Article 2219 of the same code, Civil Code, provides that moral damages may be recovered in cases of illegal detention. Privacy of communications and correspondence. Besides what Section 14 envisions is merely the enforcement of a duly issued court warrant, a function usually lodged in the hands of law enforcers to enable them to carry out their executive functions, the prescribed procedure for disclosure would not constitute an unlawful search or seizure, nor would it violate the privacy of communications and correspondence. Disclosure can be made only after judicial intervention. Aside from the purpose of the inquiry, the Constitution imposes two other limitations on the power of legislative inquiry. One, the rules of procedure for the inquiry must be duly published. Publication of the rules of the inquiry is an essential requirement of due process. Two, the rights of persons appearing before the investigating committees affected by such inquiries must be respected. These rights include the right against self-incrimination as well as the right to privacy of communications and correspondence of a private nature. The power of legislative inquiry does not reach into the private affairs of citizens. Concept of communications correspondence. The scope of the guarantee of free expression takes into consideration the constitutional respect for human potentiality and the effect of speech. It valorizes the ability of human beings to express and their necessity to relate. On the other hand, a complete guarantee must also take into consideration the effects it will have in a deliberative democracy. Skewed distribution of resources as well as the cultural hegemony of the majority may have the effect of drowning out the speech and the messages of those in the minority. In a sense, social inequality does have its effect on the exercise and effect of the guarantee of free speech. Those who have more will have better access to media that reaches a wider audience than those who have less. Those who have espoused the more popular ideas will have better reception than the subversive and the dissenters of society. To be really heard and understood, the marginalized view normally undergoes its own degree of struggle, intrusion, and how allowed. The plain view doctrine may not be used to launch unbridled searches and indiscriminate seizures, nor to extend a general exploratory search made solely to find evidence of defendant's guilt. Exclusionary rule. In People versus Jabbar, it was ruled that any statement obtained in violation of the constitutional provision, whether exculpatory or inculpatory, in whole or in part, shall be inadmissible in evidence. Evidence obtained and confiscated on the occasion of such unreasonable searches and seizures are deemed tainted and should be excluded for being an proverbial fruit of the poisonous tree. Freedom of speech. Freedom of speech includes the right to be silent. Aptly has it been said that the Bill of Rights that guarantees to the individual the liberty to utter what is in his mind also guarantees to him the liberty not to utter what is not in his mind. The salute is a symbolic manner of communication that conveys its message as clearly as the written or spoken word. As a valid form of expression, it cannot be compelled any more than it can be prohibited in the face of valid religious objections, like those raised in this petition. To impose it on the petitioners is to deny them the right not to speak when their religion bids them to be silent. This coercion of conscience has no place in the free society. Concept. Continuum of thought, speech, expression, and speech art acts. While the present case involves incident of contempt, the same is akin to a case of libel for both constitute limitations upon freedom of the press or freedom of expression guaranteed by our Constitution. So what is considered a privilege in one may likewise be considered in the other. The same safeguard, though, should be extended to one whether anchored in freedom of the press or freedom of expression. Therefore, this principle regarding privileged communications can also be invoked in favor of appellant purposes of free speech doctrines. No one seeks to deny him that right. Least of all this court, what respondent seems unaware of is that freedom of speech and of expression, like all constitutional freedoms, is not absolute, and that freedom of expression needs on occasion to be adjusted to and accommodated with the requirements of equally important public interests. One of these fundamental public interests is the maintenance of the integrity and orderly functioning of the administration of justice. There is no antinomy between free expression and the integrity of the system of administering justice. Balance between unbridled expression and liberty. Otherwise, the freedom of speech, which is guaranteed with a view to strengthening our democratic institutions and promoting the general welfare, would be a convenient excuse to engage in the vituperation of individuals for the attainment of private, selfish, and vindictive ends, thereby hampering the operation of the government with administrative investigations of charges preferred without any color or appearance of truth and with no probable effect, and the harassment of the officer or employee concerned to the detriment of public interest and public order. We will stop from there. The next topic will be types of regulation. So that's it for today. Thank you guys.